First, let's look at Part 1. Each slide lists the advantages or disadvantages of one of the three basic entity types, with a brief description of each. For members or subscribers to the Hatchery, or SBA Canada, we have downloadable content in our handouts section. This includes a copy of the scraped content from the original Small Business BC website, along with a brief discussion of each advantage or disadvantage. We also have a copy of the script for the discussion. If you wish to purchase a one-on-one workshop, we recommend that attendees listen to the compiled PowerPoint discussion, a YouTube video first, and refer to the script as required. You will also need to fill in the registration form, providing details about your business and goals in attending the seminar. This will help us ensure that your session is useful.
Okay, Randolph. First, I'll type out each of the alleged advantages or disadvantages in turn. Then you go on to explain what the author meant and explain whether it really is an advantage or disadvantage. Then give us your reasons. First advantage, low startup costs.
It seems like the author was only referring to legal organization costs. If so, the statement is true, although that is usually a pretty trivial cost when compared with other common startup costs. For instance, the cost of renting a business location, buying a vehicle, a computer and software, or purchasing a set of tools can all be much higher than legal costs on starting a business.
Second, greatest freedom from regulation.
Once again, it's hard to know which particular regulations are being considered. For instance, many businesses require licenses to practice. A taxi driver usually requires a taxi license. You can't practice law, open a CPA practice, or offer healthcare or certain engineering services without a license.
The BC Association of Professional Engineers recently approached one of our clients. For over 25 years, our client provided project management and other services to manufacturers throughout North America. Apparently, the professional engineers had recently convinced the provincial government to redefine the term engineering services in law. Now armed with new legislation, the independent regulatory body began approaching businesses like my clients and threatening them to cease and desist from violating their newly amended act.
It seems that professional bodies invariably claim that they are protecting the public when they seek to extend their scope of practice. Yet, there isn't anyone protecting the public from the excesses of the professional bodies themselves.
Third, the owner has direct control over management.
An individual owner can incorporate his business and become the sole shareholder, so the degree of control is precisely the same whether a single proprietor owns the business or a single shareholder does. If your business has more than one location, the manager at any of your locations will most likely be able to bind the business legally.
Fourth, a proprietorship only requires a minimal amount of working capital.
Surely the amount of working capital is mostly determined by the type and size of the particular business. The type of legal entity used has little impact on the funding required.
Fifth, possible tax advantages of a proprietorship structure.
There are different tax advantages that accrue to businesses with different legal structures. We'll discuss these later on.
In a proprietorship, all of the profits go to the owner.
No matter which legal structure is selected, all profits go to the owner or owners. It's a little baffling that the author thought this should be considered an advantage of a proprietorship structure. The same is true of a corporation with a single shareholder.
Unincorporated entities like proprietorships have unlimited exposure to liability.
Driving a car can expose us to virtually unlimited liability if we injure someone while driving. In that case, we use insurance to protect ourselves. Corporate lawyers often emphasize the importance of incorporating businesses to protect owners from liability to customers and the public at large. But most often, insurance is required in any event, even if you do incorporate. Owners of small corporations typically will have to provide personal guarantees when borrowing money. They are also responsible to the public, the government, and to employees as directors. If you form a small business corporation, you will almost certainly be a director and be subject to director's liability.
If a proprietor dies or becomes disabled, the business will lose its leader in their absence.
You're right. The author seems to be referring to the fact that if the owner of a proprietorship dies, the business dies with them. However, the individual owner's assets and liabilities will remain with their estate. What disappears is the owner's management oversight. The business can continue if someone steps in. A small, closely held corporation isn't very different in this regard.
A proprietorship typically finds it hard to raise money from investors.
Regardless of its legal structure, it is difficult for any small business to raise capital. The author also failed to mention that a business structure invariably can be changed to meet the needs of investors if required. This actually happens quite frequently when a business grows. It is usually better when an investor or buyer emerges to restructure the business at that time to suit both parties. A proprietorship or a partnership that operates under a business name within a particular geographic area will have some limited rights to use that name within that geographic area. Even a corporation may have little protection outside that area. However, when this is an issue, there are other strategies available. For instance, you might consider incorporating a company under a desirable name, and then rent that name to your proprietorship. Or, if you already have a name to protect, you could consider getting a trademark or a wordmark.
In theory, a partnership can be easily and inexpensively formed.
It is quite easy to create a partnership. However, that may also be a disadvantage. If you agree with someone to operate a business in common, you have formed a partnership. While it may be easy, it's also dangerous. How do you know what was agreed to if it wasn't written down? If you didn't write it down, you'll probably inherit the standard terms of a partnership agreement as defined in the Partnership Act of most, if not all, jurisdictions in Canada. If you do, it is probably wise to engage a lawyer to ensure that the terms are properly drafted. This can easily be more expensive than forming a corporation. Certainly, two partners can both contribute their own assets to the partnership. Your partner's assets would be an additional source of capital. But this can be dangerous as well. See also mutual agency under disadvantages. Once again, there are different tax advantages that accrue to businesses with different legal structures. We'll discuss these later on. As we said before in relation to a proprietorship, it's hard to know which particular regulations the author is referring to. The need to simply file a corporate tax return for a corporation can hardly be said to be more onerous than the requirement to file Form T5013 for a partnership. There is still the issue of occupational licenses in many cases. Regardless of the structure you choose, many environmental and consumer protection regulations may impact your business. Insurance may be more important than unlimited liability or a corporate veil in many occupations or industries. In a proprietorship or a corporation, you can hire management talent instead of adding an equity partner. Or you might consider a corporate structure with two shareholders and thereby accomplish the same thing. As we said in the section on proprietorships, corporate lawyers often speak of the importance of incorporating to provide protection from liability to customers and others. But, most often, insurance is required in any event. Corporations typically will have to provide personal guarantees when borrowing money. They are also responsible to the public, the government, and to employees as directors. If you form a small business corporation, you will almost certainly be a director and be subject to directors' liability. In partnerships, there is also the issue of mutual agency, which we will discuss below. This is the downside of not getting direct control in a proprietorship or a 100% owned and controlled corporation. Every entrepreneur loves the idea of a silent partner who just gives you money and lets you make all the decisions. But then, most of us would like to win the lottery or inherit a fortune. If you want the additional resources and expertise of a partner, you have to expect to give up some control. Just as we said when talking about proprietorships, it is difficult for any small business to raise capital, regardless of its legal structure. The author also failed to mention that a business structure invariably can be changed to meet the needs of investors if required. This happens quite frequently when a business grows. When an investor or buyer emerges, it is often better to restructure the business to suit both parties at that time. Human resources are key to any business. This applies to employees, investors, and advisors, as well as to partners. In partnership law, mutual agency refers to a legally binding relationship entered into by business partners. In this arrangement, each partner becomes an agent of the business. Partners have the authority to make business decisions on behalf of the partnership. They can create binding agreements with third parties. This concept ensures that partners share responsibilities and act collectively, even if they don't always agree. It's like a business marriage, where partners are accountable for each other's actions within the scope of normal business operations. A limited liability partnership, LLP, or some other form of limited partnership, is sometimes a good alternative. Presumably, the author was referring to the fact that if a partner dies, the business may die with them. In fact, most default partnership agreements found in provincial partnership acts will contain a clause stipulating that the partnership will dissolve upon the death of a partner. Partnerships may avoid this potentially undesirable result by having a lawyer draft their partnership agreement and ensure that the death or retirement of a partner can be accommodated in an orderly and predictable way. A proprietorship or a partnership that operates under a business name within a particular geographic area will have some limited rights to use that name within that geographic area. Even a corporation may have little protection outside that area. However, when this is an issue, there are other strategies available. For instance, you might consider incorporating a company under a desirable name and then rent that name to your proprietorship. Or, if you already have a name to protect, you could consider getting a trademark or a wordmark. As we said in the section on proprietorships, corporate lawyers often speak of the importance of incorporating to provide protection from liability to customers and others. But most often, insurance is required in any event. Corporations typically will have to provide personal guarantees when borrowing money. They are also responsible to the public, the government, and to employees as directors. If you form a small business corporation, you will almost certainly be a director and be subject to director's liability. In partnerships, there is also the issue of mutual agency, which we discussed earlier. As discussed earlier, there are different tax advantages that accrue to businesses with different legal structures. We'll discuss these in Part 2, after we complete this review of the alleged advantages and disadvantages of each of the three structures. In a proprietorship, partnership, or corporation, you can hire management talent instead of adding an equity partner. It's hard to understand what they were thinking here. In most small private corporations, there are usually restrictions on selling shares without the approval of other shareholders. I fail to see how this is an advantage of a corporate structure. Corporate lawyers and introductory business law textbooks often promote the notion that a corporation is a separate legal person and therefore does not die. In our view, that may be theoretically true. But, according to Microsoft's Copilot, trends look like this. Small and medium-sized enterprises, SMEs, typically have an average lifespan of less than 7 years. Multinational companies tend to survive for 10 to 12 years. Large enterprises. The longest lifespan is for large enterprises, which is still less than 40 years. By way of comparison, in 2022, the average life expectancy for a Canadian at birth was 81.3 years, which is a full year lower than the 82.3 years recorded in 2019. But that is still more than twice as long as even our largest businesses. From our perspective, that's kind of like counting the continuous existence benefit twice. Separate legal entities are good for accountants, though, since each will be required to file tax returns, which is, after all, our bread and butter. As we said, in relation to both proprietorships and partnerships, it is very difficult for any small business to raise equity funding. Although if the business is promising or highly profitable, it is a fairly common practice to restructure a business to meet the requirements of investors or purchasers. Name protection is somewhat easier for a corporation. For a successful business, though, there are alternatives, like trademarking. A corporation could also be formed to hold a valuable name and rent it to another business. But name protection only usually extends to the geographic area in which the corporation operates. Once again, it's hard to figure out which regulations the author was alluding to. Public corporations are, in fact, quite highly regulated, but they're also quite rare. Of course, they are more common in Canada. In our view, this is more a function of auditors, securities lawyers, and Canadian stock exchanges selling Canadian small and medium-sized enterprises on the benefits of going public. For what it's worth, we believe that American private equity is a more useful vehicle for growth companies in Canada. While a proprietorship is clearly simpler to organize, partnerships, limited partnerships, and LLP structures can be even more expensive to set up. A partner's agreement can be just as restrictive as either a shareholder's agreement or charter restrictions. A small private corporation can get away with filing an annual report on their own, without much help. Larger companies should certainly do more. However, in our experience, many legal firms struggle to provide record-keeping effectively for their smaller clients. These smaller corporations form the vast majority of business corporations in Canada. As a result, many small corporations are often non-compliant. Our tax system was put together based upon the theory of integration. The theory of integration in Canadian tax aims to ensure that the combined tax burden on corporations and their shareholders is roughly equivalent to the tax burden that would apply if the corporation's income were earned directly by the shareholders. In other words, integration seeks to create parity in after-tax cash received by individuals, whether income is generated directly as salary or distributed as dividends from a corporation. As discussed in the previous slide on limited liability, owner-managers, shareholders, and directors of small corporations generally must provide personal guarantees when borrowing. They are also subject to legal claims for failing to act responsibly in their capacities as officers and/or directors of these companies. So, much the same as sole proprietors and partners in unincorporated businesses, insurance is usually a good idea, even for incorporated businesses. Once again, the supposed advantage is really theoretical, particularly in the case of small private corporations.
Tell me, what did you think of the summary from Small Business BC?
To be quite truthful, it seemed to me like a large serving of pointless sophomoric twaddle.